Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1743. Gerald D. Lavage, appellants versus District of Columbia Housing Authority et al. Mr. Chan, amicus curiae for the appellants. Mr. Douglas for the appellants. Good morning.
Good morning, Your Honors. May it please the Court. My name is Hugum Chan, amicus curiae counsel, and I'm presenting arguments in favor of pro se appellant Gerald Lavage. I'd like to reserve 2 minutes for rebuttal. Our collective life experiences should reasonably inform us that when someone accuses another of misusing a credit card, that the accuser also identifies the allegedly unauthorized transactions to the accused so as to allow the latter to respond accordingly.
But we're here more than just about unauthorized transactions. Isn't it also about taking a trip to Maryland?
Your Honor, that is part of the unauthorized transaction. That's part of the unauthorized transactions. That's part of the accusations that it occurred in Maryland. But the actual trip or the alleged trip to Maryland, that doesn't form the basis of why the agency was about to terminate Mr. Lavage. What we're focused on is the list of 26 disputed transactions that were identified in the draft notices of disciplinary action. Mr. Lavage did not receive procedural due process because DCHA did not, or DC Housing Authority, did not identify the disputed transactions underlying its charge of credit card misuse against them. It did not provide him with the underlying evidence in support of that charge, and it did not afford him a meaningful opportunity to respond to the charge. I'll address each of these failures in turn, each of which must result in the reversal or vacator of summary judgment.
But you still have notice of generally unauthorized transactions related to a gas card. And so why isn't that broad enough and narrow enough for you to know what is at issue, for a termination?
Yes, Your Honor, because this court's precedent has said that in order to have a meaningful opportunity to respond to a charge that leads to a deprivation of a right, the plaintiff has to have notice of what those charges are.
But or given the opportunity to provide receipts.
Your Honor, that is the defendant's primary argument. However, it's legally irrelevant that the agency asked for those receipts. The burden of ensuring—
Ask for the receipts, then you can put it together with the transactions.
Your Honor, not if Mr. Lavage doesn't know what receipts he has to turn in. Because according to him, well, it's his position, at least from the record, from what I could see, that he did turn all of them in. And so he needs to know what those additional disputed transactions are so that he can defend for himself. So, for example, it may be that the other charges were made by somebody else. And there's actually record evidence to support a reasonable inference that someone else may have actually had the credit card and was making the unauthorized transactions.
Is it in the record what the terms are in terms of the responsibility of the employee who is given an agency credit card? I mean, it seems to me and I haven't seen that argued in this case, but if by issuing an agency card to the employee, the agency and the employee agree that the employee is effectively the guarantor of the use of that card when it's in the employee's possession, that seems to me that would bear on this question. But we don't know anything about that in this record.
Sure, Your Honor, I think that's correct. We don't know anything about that, but there's a reasonable inference to be drawn from the record that he may not have had possession of the credit card for these 26 allegedly unauthorized transactions.
Are you suggesting some other employee or someone else in the agency, or rather someone in his household or
I think all of those could be reasonable inferences, but what I can, if the court would like, I can walk through the joint appendix, specific
But he
pages.
was also supposed to turn the credit card in every day, right?
Correct. And the record reflects that he did. But that doesn't mean that somebody else didn't take out the credit card. And it could have been all, without any malicious intent. It could have been a mistake that somebody else checked out the credit card. But on the facts of this record, there's a reasonable inference to be drawn that Mr. DeVage didn't necessarily make all of the alleged disputed transactions.
Did he really try to engage, with the company with respect to asking for the additional information when he had lots of opportunities between when he first learned about all this in November up until the actual date of alleged termination and or resignation?
The record doesn't seem to reflect that he did. But again, Your Honor, the burden of ensuring compliance with due process is on the agency. It was incumbent on the agency to inform Mr. DeVage which transactions it deemed as being unauthorized or unsubstantiated with receipts so that Mr. DeVage could meaningfully defend himself and potentially submit any additional receipts that he may not have turned in previously.
And then just going back quickly to the charge in Maryland, you earlier were trying to make that some kind of separate issue or something that he was not informed of, because if he was, that's a yes or no answer. Did you go to Maryland or not? And is Maryland in your district?
Well, he wasn't, Your Honor, he wasn't, the charge against him is having disputed unauthorized transactions. So whether he made those unauthorized transactions in Maryland or he made them in DC, that's not really the point of why they were trying to terminate him. It was the fact that it was a disputed transaction. So in that particular example, it could have been in DC. That transaction could have taken place in DC, and the agency still would have charged them with credit card misuse.
So you would agree that if Maryland is not his district, he should not be there?
That's correct. If at least based on this record, that's what I can tell. But again, that shouldn't take away from the point that he didn't have notice as to which transactions were allegedly in Maryland or just more generally unauthorized. Again, defendants have cited no case law that holds that a plaintiff like Mr. DeVage has a responsibility to proactively figure out the factual basis of the actions taken against them or affirmatively request that the government provide him with the evidence in support of those transactions.
Let me ask you, Mr. Chan, did Mr. DeVage's resignation, I know it's disputed or there's a question in the briefing as to whether it was voluntary, but did the resignation render him ineligible for a normal grievance process? The fact that he left and was no longer an employee?
I think at least based on this record, and it's my understanding from reading it, that it looks like he didn't get those post-termination processes because he wasn't treated as being effectively terminated.
And how can we conclude that it wasn't a voluntary termination? And I know there's an argument that there was a misrepresentation, and what I understand that to be was that the agency expressed an imminence about delivering the notice of termination that was inaccurate. Is that right?
Yeah. This court, in order for this court to reverse or vacate summary judgment and remand for further proceedings, it doesn't have to conclude that there was in fact a involuntary resignation. There just has to be a genuine disputed material fact over it. And certainly the record allows this court to draw that, which is why it would be inappropriate to affirm on that alternative basis.
So tell me about that genuine disputed material fact. Am I right that the asserted misrepresentation was that the agency said on the 22nd, we're going to deliver this termination package to you on the 22nd, and it'll be done. And that therefore, Mr. DeVage was feeling like, I need to decide ASAP. And I take it that he claims that affected him because he wasn't able to get more information. Is that the nature of the misrepresentation?
Yes, Your Honor. It's both I believe that those are grounds sufficient to support misrepresentation as well as duress under the case law.
And in terms of misrepresentation, though, the misrepresentation has to be material. It has to be something that, had it not been communicated, things might have come out differently for the plaintiff. And I'm not sure I follow like the train of reasoning of what would have come out differently had they said, hey, we're going to serve this on you next week, or we're not quite ready, but this is our plan.
So I think, Your Honor, the inquiry focuses less on the outcome or the result and more about the process. Right? The case law suggests that the touchstone or the touchstone of the inquiry is about being able to make a voluntary and informed choice. And so even if he would have been given more time and decided to resign, that's not the sort of right lens to look at this inquiry. It's about whether or not he had sufficient amount of time to make an informed decision.
Except that did he, if it had come later, there has to be materiality, right? A misrepresentation can't just be any random misrepresentation. It has to be a misrepresentation that harmed him. And you're saying, well, it harmed him because he didn't have time to get more information. And then the next question is, why is that material? What could he or would he have found out that might have changed his calculus?
Your Honor, I see that my time is up. My answer.
No, you can continue as long
Okay.
as we have questions.
Okay. What it prevented him from doing was making an informed choice. So he, for example, couldn't get information about what the financial consequences or hardship would have been if he had decided to stay on the job and decided to subsequently challenge his termination. So
Can you say more what you mean? What financial consequences?
So, for example, as a general matter, if you're terminated versus as opposed to being resigned, it might affect, for example, subsequent unemployment benefits. Maybe it affects how your retirement benefits are discharged. Maybe it affects your health insurance benefits. All of those types of benefits that come as a perk of a job. He wasn't able to figure out what the consequences were.
But there's no better news that I can think of that he would have gotten than what he was already fearing, which was those would have been in jeopardy.
Those would have been, well, he was entitled to learn about the fact that they were informed.
Except if what he learned would have absolutely been what he was already assuming, then the putative misrepresentation is just not material.
Well, it's still, I don't know if that's, I would respectfully disagree with that, Your Honor. But, and the second point would be that the folks that he was getting information from with respect to any sort of job benefits were folks that didn't even have full notice of what the charges against him were. And so they couldn't have reliably given him appropriate advice such that he could have made an informed decision as to whether to resign or stay on the job and challenge termination.
All right, I have a question
Yes.
for you, and it may take some time. I know you were not the lawyer in district court, but how closely did you review the docket in district court?
I would say I did review it, and I'm happy to try to answer any questions.
I'm looking at Exhibit 6, which is a notice of disciplinary action. The very month this was going on, Mr. Davage was stopped for running a red light in Maryland. He had his son in the car with him. He gave, and it's a document in the district court record, several pages notifying him of his rights and so forth, the very month that this was going on. Now, I'm going to ask the other side, why on earth they didn't tell us about this? Because it shows that he knew the whole notice of disciplinary action procedure. He was being subject to it at the very same time as this gas purchasing going on, with misuse of the vehicle with his son in it, driving in Maryland when he was supposed to be inspecting houses in Southeast Washington. And you don't know anything about that.
I don't know the actual, the underlying basis. I did review that in the record, and I don't perceive that to be necessarily relevant to the issue that we have here. Again, he needed to have notice provided by the agency.
Trying to focus this on only gas transactions when one of the allegations is that he was unauthorized to be in Maryland. You keep trying to separate that or turn it into a transaction.
Yes, so if Your Honor, JA 133 through 134 and JA 140 through 141, those are where the two draft notices of disciplinary action are that are relevant to this case. And I don't believe if you read those two particular notices, there's anything mentioned about driving in Maryland as being the cause for why they want to terminate him. It is strictly focused on making unauthorized transactions. So again, even if the Maryland transaction had occurred in DC, that wouldn't have led to the agency withdrawing their basis for wanting to terminate him.
So just so I'm clear, you think that Exhibit 6, which sets out exactly what I have said, is not relevant to this case
No, because what we are focused on is
as far as notice?
as far as notice, because the
Okay.
notice is
Great, thank you. I don't have any other questions. Do you have any? No, right. Okay, we'll give you a couple minutes. Mr. Douglas.
Good morning, may it please the court.
May I ask you why you did not inform the court of this additional?
I believe that has been, we have informed the court of that. I believe that, Your Honor, if you look at our underlying, well, it's in our underlying motion for summary judgment. And what that goes to is not the unauthorized transactions.
I mean, this court, in your brief.
Your Honor, I believe we did. We made reference to it because the point we were making about that transaction in Maryland, it goes to whether or not Mr. DeBage understood the grievance process.
Yes.
And I believe we pointed out that he did understand the grievance process. I believe we pointed out that Mr. DeBage had grieved in the past. He grieved this particular matter. He grieved another matter in which he was up for termination, is my best recollection, that he prevailed.
He got 3 days of suspension or something.
He got 3 days of suspension for that matter, that is driving in Maryland.
With his son, which was against company regulations.
He was using the car for personal purposes, and that was against the regulations of DCHA. With respect to what took place in November of 2017.
Well, this is November of 2017.
Yes, Your Honor, but it's a different incident, and it's not the incident that went to the notice of proposed discipline here. He was
It happened on September 21st of 2017.
Yes, Your Honor.
And the notice he's getting is November of 2017. Go on with the rest of your argument.
Your Honor, before the court is the intention that Mr. DeBage voluntarily or involuntarily resigned, and the argument focuses upon whether or not he was given notice of what was being investigated. What happened here factually, Your Honor, is this, that in an audit of the October 2017 American Express bill and credit card for which Mr. DeBage had been assigned, there appeared to be several transactions. First, DCHA had a procedure that the use of the credit card had to be logged in and a receipt provided so that in an audit, they could compare the receipt to the charges. For the charges that were in October of 2017, there were approximately $332 in charges for which there was no receipt.
Question, I have a question about whether, I don't see anything in the record saying that DCHA did have the credit card receipt or the credit card statement.
The American Express statement, yes, you did.
So DCHA had that statement, right? And DCHA does not claim that it ever gave a copy of that statement
It
or
did
the
not.
relevant charges, or showed a copy of that statement to Mr. DeBage?
No, what DCHA states, and I think the record sustains, is that Mr. DeBage was asked to attend a meeting between Mr. Dyer, Ms. Russell, and himself. And he was asked questions about the October 2017 charges. And specifically, he's asked questions about, one, why are there charges in Maryland? The district in which you are basically providing services is in the District of Columbia. There are no units to inspect in Maryland. So what are you doing in Maryland getting gas? Two, there are charges on this card for which there are no receipts. You are obligated to provide receipts for each and every transaction. Three,
Yeah, okay, keep going.
Three, the amount on the card seems to be very, very high. It's $532, which is higher than the average use in that month or for other persons who were doing the same job, that is, inspecting properties in the District of Columbia. He's asked specifically, did you do charges in Maryland? He says, no, I did not. I didn't do it. He says, he's asked specifically where the other receipts are. And he says, I've turned my receipts in.
Right. I guess what I'm thinking is, given that the case law says that an employee is entitled to an explanation of the evidence that puts him on notice and enables him to respond. If my spouse came to me and said, wow, there's all these charges on the visa bill, have we talked about all the big spending you've been doing?
Yes.
And I would say, I think so. What do you mean? Well, it's $2,000, over a series of 10 transactions. I would be like, if you showed that to me and I could see, one was for auto repair, another was for the bookstore where I was buying a gift for, our cousins, remember, honey, I don't think any of us would be able, in that sort of black box, confronted with that black box statement, there are more charges here, that we would be able to jog our memory and say, well, right, oh yeah, I did swing up, Georgia Avenue, and I was in Silver Spring and not in DC where I filled the car. I mean, it just, as a matter of due process, it seems like the key thing would be to provide, and I'm not saying there's not a reason to go into an inquiry and a reason to confront the employee about this, but in terms of what gives the person process, it's hard for me to think that anything short of the statement that, in fact, gave the agency, raised the questions for the agency, would be what the employee would need to be able to see.
Well, Your Honor, if I may, let me take the example that you've just given. And not to personalize, but to use it. I come home and I say, I've just gotten the American Express bill for last month. Okay. Now, there's no reason for you to be in Maryland at all. But yet there is a charge here in Maryland. Showing you the receipt that there's a charge, showing you the statement that there's a charge in Maryland does you no good. There's a charge in Maryland.
Again, driving up Georgia Avenue toward Silver Spring, am I in DC? I just feel like if you're asking someone to confront what is giving you concern, and what about the other charges? And there's one about Maryland. What about the other charges?
There are other charges and there's no receipt at all.
Right.
And you're supposed to provide the receipts. Where are the receipts?
So if they're all, where employee B lives and that employee, it just seems like you have in hand
We have
the most relevant information that would jog, if somebody were not culpable, that would give them a basis for saying either, whoa, that is totally not me, or, oh my gosh, let me tell you what I think these are about.
Well, Your Honor, in terms of what's going on here, and remember, this is a pre-termination issue, and the reasons behind that is you give the person an opportunity to respond. He specifically asked to respond to the question of having the charges in October 2017. And he does respond. He says, A, I didn't do it. I think I turned in all my receipts. And he's then asked to provide the additional receipts. So giving him the statement and saying, look at this particular day. Do you have a receipt for October the 1st? You were obligated under DCHA procedures to provide a receipt each and every time you use the card.
Right, but his position is, I gave you the receipts, and you're saying, well, that means he's not complied with respect to their charges. And I guess the question is, isn't he entitled to try to explain the charges that you're saying he's responsible for which he doesn't have receipts? Unless you're saying the fact that he is the issuee of the card, then just res ipsa loquitur, everything that flows from that, he's the guarantor of those expenses. I don't hear you making that argument.
Well, if I have to, I will.
But you haven't made that argument.
I've not made that argument.
See no policy of the agency on that ground, but it sounds like that's your assumption.
No.
Whereas, you know, and maybe he was insufficiently vigilant about somebody else having access to the card, or maybe when he turned it in, it was given to somebody else. But he can't even address that.
He does not say that, Your Honor. He does not.
It's your burden to give him process.
I'm giving him process. I'm asking him about the charge. I'm asking him to provide all receipts to me.
Right.
We say to him at the end of the meeting, we say before the meeting, by way of email, bring the card to us and bring in all receipts. At the end of the meeting, we say, look, we're going to look at the entire transactions that you've had when you've had this card in your possession. And what's said to Mr. DeBage at that point in time is, you know, you admit you've had the card, you've not turned it in, you violated our procedure.
You admit he hasn't turned it in?
I
thought he denied that.
No,
I thought he said he did turn it in.
No, he says he did turn it in, Your Honor, and that is made in his motion for either his opposition or his motion for summary judgment. He says, I did turn the card in. He may have also said that to Mr. Thaxton, that he had the card in his possession in all but 6 or 7 times. He did not turn it in.
Do you have sites for that? I'm not sure that I know where you're referring to.
It would be I think would be the Thaxton affidavit, Sean. I do not.
Thaxton affidavit? That's not his affidavit.
No, it's not his affidavit. I think, well, excuse me, Your Honor. I think that he does supply an affidavit also, and I'm just not remembering. I'm trying to be very accurate in terms of where it's coming from. I know that in the opposition to the motion for summary judgment, one of his contentions is I told Mr. Thaxton that I kept the card. He says something in terms of keeping the card. And all for 6 or 7 occasions. I'm getting.
You would say he didn't turn it in daily.
He didn't turn it. You know, our contention, Your Honor, is that. And again, this is a pre-termination proceeding. It's not a pre-termination. It's not a proceeding. It's basically DCHA saying to a person, "Look, we think there's been misuse of the credit card. You don't deny that you've had the credit card in your possession since the time it was issued. At some point in time, there is a denial. he's given, and the issue that I'm having here is that he is told what's at issue. He provides a response, and the issue is he's not terminated then. DCHA basically does not do that.
Okay, so let's be clear about exactly what he is on notice about,
Mhm.
and then how he responds to what you put him on notice about, so that we can see if those two match up.
Sure.
And then the next question would be, what do you perceive Loudermill requiring? Because it says that oral notice and an explanation is all that's required.
That's correct, Ron. We contend, first of all, that there are two key meetings. The first meeting being that among Mr. Devage, Mr. Dyer, and Ms. Russell. At that meeting, he is put on notice about the charges in Maryland. The charges being that, one, there's a charge in Maryland, and a use in Maryland that for which there's no receipt. And the question is, why is there even a charge in Maryland, since it's an issue, since the card is supposed to be used only in the District of Columbia? Two, he's put on notice that there are charges for which there are no receipts at all. Three, he's put on notice that there is an unusual amount of charges. That is, there's got to be some justification for $532 of charges in the month of October, when all you're supposed to be doing is buying gas. Okay, so that's what he's put on a notice, I believe on November the 7th. He is put on notice that DCHA is going to be, in that meeting, he's put on notice that DCHA is going to be looking at all credit card charges from July through the end of October, July 2017 through the end of October. He receives a card in June. It's in that meeting in which there's the issue of whether or not he's asked about, he's told that he has not turned the card in every day, that it's been in his possession since the time the card was issued in June until he was asked to turn it in.
But the fact that there is some evidence that supports the agency's view
Yes.
doesn't mean there's no factual dispute on that point. So that's, I mean, we're at summary judgment. I'm not saying that no reasonable fact finder could agree with the agency, but when we're in a summary judgment posture, the question is, would any reasonable fact finder have to credit the agency's view over Mr. Devage's? And Mr. Devage has said he turned in the card. You're saying he didn't. Why is that not a disputed factual issue for a fact finder?
No, the question is, the question is whether Mr. Devage's resignation is voluntary or involuntary.
That is also a question.
And the issue is whether Mr. Devage was afforded all the procedural due process that the Constitution requires at this stage. I mean, because what Mr. Devage is doing, he does not contest the fact that, yes, I have resigned. What he asserts is that you just didn't give me constitutional process.
I think what he's asserting is that, but that the misrepresentation was that the agency was ready to serve him with the notice of termination on the Friday, the 22nd of December. And that it turns out, we now know that it actually wasn't ready to do that then. So he's making an averment that the misrepresentation that rushed him, he couldn't get in touch with people. It was an employee holiday party, and that there was some information that he lacked that if it hadn't been falsely claimed that it was imminent, that he might have obtained. Is that the way you understand his claim? I'm not asking you to agree with it, but I'm asking whether
No, I don't understand his claim to be that, Your Honor. I understand his claim to be, and
what do you understand to be what he is identifying as a putatively material misrepresentation?
Well, I understand that he is now asserting, and I understand that he is now asserting the fact that the agency had not reached a final decision.
But it said it had.
It did not say that, Your Honor.
Okay, I'm trying to understand what you're characterizing as your understanding of his claim that there was a material misrepresentation.
At best, as I understand it right now, Your Honor, is this. Mr. DeVage is taking a conversation between Mr. Thaxton and Ms. Gillis, and is saying in that conversation, when Mr. Thaxton in effect says two things. First of all, or really several. One, I've recommended termination here. And he says to her,
He being
Thaxton, I'm waiting for one signature. I have all but one signature. And he says, that's what he says to her. And this is with Miss Gillis, who, as I understand it, understands what the process is. That there has to be at least, that two departments have to sign off on it. And all he's doing right now is just waiting for one department to do that. And he explains to Ms. Gillis that he believes the agency is firm in its conclusion to terminate him because of the prior grievance and the prior discipline, or really the prior discipline, and the fact that what's at issue here is whether or not there is theft. And under the table of penalties, there is no other discipline that can be imposed.
So why isn't what you just described, they didn't yet have the second signature.
Yes,
So they weren't actually ready to serve the notice of termination the following day. They had to get that signature.
that's correct.
Okay, so they didn't have it all signed, sealed, and delivered. That's that's all I understand his claim to be. I'm not saying
But even if
I'm not saying it's necessarily gets him where he wants to go. I just, instead of fighting the record on that, I thought, which, includes a disputed material fact, I thought you might respond why that isn't material.
well, it's not material, Your Honor. It's clearly not material in terms of what the resignation here is, because the reasoning behind Mr. Gillis's determination, I'm sorry, Mr. DeVage's decisions to resign, he clearly states that I'm looking at it and I'm concerned that they could criminally prosecute me. It has nothing to do with the signature. And as to when the signature is obtained, Mr. DeVage is operating under the assumption, again, given to him by Ms. Gillis, that if he resigns, he can avoid any sort of prosecution at all. The idea being, if I resign, no discipline proceeding can be initiated against me. And Mr. DeVage says that.
But does he have any post-resignation / termination rights?
Post-resignation? No, because he's resigned.
Okay.
When you say he says that, where does he say that? I'm sorry, just wrapping up the.
We quote his deposition transcript in our brief, in which he says that, in which a question is asked of him, about why you're resigning. And he says, it's the criminal charges, the possibility of being criminally prosecuted.
Okay. Do you have any more?
You don't know the page cited in JA for that, do you?
Read my page, say that.
Court's indulgence, I think I'll have in a second. Um, um, that's, there's reference in the brief, there's reference to it, the joint appendix, page 250. But the deposition testimony that's quoted is, I'm looking for that right now. No, it's not that. It's my questions at the end of this deposition. And I don't have that right to pay the court right now. So I don't want to give a miscite.
Right.
More importantly, to answer a question that had been posed, Mr. Devage is told that you should not resign. You should wait to see what the charges are that are being presented against you. And once those charges are being presented against you, the union will do all that it can to assist you.
I do have any more questions. All right, thank you.
Thank you.
Does Mr. Chan have any time left? All right, why don't you take 1 minute?
Thank you, Your Honors. I would like to, with the 1 minute that I have, I'd like to try to address just two issues.
Okay.
First, I want to go back to this Maryland charge because it seems to be, I think it's an exemplary of the issue that we have here, which is just because he's told that there was an allegedly unauthorized transaction in Maryland, that's not enough, right? Because we didn't hear, what I didn't hear my friend on the other side of the aisle say was that there is no reasonable inference to be drawn from this record that someone else had that credit card and could have made charges to it. And so telling him that, hey, there's an unauthorized charge in Maryland doesn't allow him to, for example, track down whether or not he was working on the day that the charge was made in Maryland, or whether even, his schedule, took him to homes that were anywhere near the Maryland or DC border. And so that is why it's important to give him at least the dates of when these transactions occurred. And that's the same issue with the rest of the transactions. He can't meaningfully defend himself if he doesn't know what the other transactions are. In fact, he was deprived of even the meaningful opportunity to make the defense that somebody else made the unauthorized transactions. And two, with respect to the voluntary or involuntary resignation issue, again, this court should remand to the district court in the first instance because the district court didn't consider it. But even if it wants to address it on the merits, Judge Pillard is right that at least with respect to misrepresentation, it was that they told them they were ready to terminate him on December 22nd. They weren't. So that's involuntary resignation with respect to misrepresentation. But there's also a disputed material fact concerning whether his involuntary resignation was a result of duress, meaning he was under a compressed time frame to decide whether to resign or to stay on the job and be terminated, all while without adequate notice of the disputed transactions, without counsel, without the benefit of knowing what the financial consequences were, and with the prospect of facing criminal charges. So in conclusion, this court should reverse or vacate the entry of summary judgment against Mr. Devage.
All right, Mr. Chan, you were appointed by the court to represent Mr. Devage. We thank you for your assistance.
Thank you.
91. Saad bin Khalid, the balance versus Pamela Bondi, Attorney General of the United States, U.S. Department of Justice, in her official capacity only et al. Mr. Abbas for the balance, Mr. Waldman for the police.
Good morning, Your Honor. May it please the court. The district court erred when it conflated the watch list orders with the no-fly list orders, concluding mistakenly that one was inescapably intertwined with the other. But that's not the case, Your Honor. These watch lists, although they are one part of a single database, they're separately applied standards. There's a secret, undisclosed standard that the government has never acknowledged what it is regarding the selectee list. There's a what the government calls a reasonable suspicion standard that governs the inclusion of the terrorism screening database. And then there's another standard that governs the inclusion on the no-fly list. All three of those standards are applied in the first instance, not by the TSA administrator, but they're applied in the first instance by the Terrorism Screening Center. And you can be on one and not the other. And for that reason, the court made an error in conflating all three. But beyond that, the watch list consequences show that the ramifications of being on these secret lists goes far beyond the airport. It goes far beyond commercial air travel. It includes things like how you're treated at the border. For example, if you're on the watch list and you show up at the border, whether it's by plane, by foot, by car, your electronic devices are subject automatically to search. They assume, because of your status, that they can take your device, look through it as they please. That's not the approach that they take to other travelers that are not on the list. That's a consequence that doesn't involve the Transportation Security Administration at all in any kind of way. It's the Terrorism Screening Center on one hand making the listing decision. It's the Terrorism Screening Center making the list available to Border Patrol agents who then use that list to decide how to treat people at the border. Not only so that's an example of a watch list consequence that is created by the Terrorism Screening Center putting somebody on the watch list, sending that to CBP, but they send it everywhere else in the federal government too, and that creates all sorts of consequences. Another specific consequence arising from the watch list's dissemination to the USCIS is the processing of Saad bin Khalid's wife's immigration papers.
Can you point to any cases which essentially a person is placed on the no-fly list and that's not been rescinded, and then yet you get to go have your entire case litigated in the court?
Your Honor, these cases are being litigated in district court all the time. There's a District of Maryland case.
That's where they're starting, correct?
Well, Your Honor, this 46-110 argument, if that's what you're getting to, is failing all across the country in district courts everywhere. And I think, Your Honor,
By failing.
the cases are being heard in the district courts.
Having been remanded from the circuit court?
And yes, they're being heard in district court because the district courts, for the most part, accepting the current.
I'm trying to have the distinction. Are they initiated in district court?
They're initiated in district court, the government.
And then there's not a final order at that time that then brings it up to circuit court?
No, Your Honor, there's plenty of cases where there are TSA administrator orders and the cases are still being heard in the district court. The District of Maryland currently is hearing a case where there's a TSA administrator order.
And if they're still being heard, then that means that TSA has not appealed it in using the 46-110 exclusive jurisdiction.
Well, that case is still ongoing, so I'm sure they'll appeal formula at the end. But that's not the only time a district court has rejected the 46-110 arguments.
Reverse then, for circuit courts, are you aware of cases that are in circuit court and then they get remanded to do what you're requesting?
Yes, Your Honor. The Fourth Circuit just in August and September, just very recently, in Long, Saad Long v. Current Saad Long v. somebody. I'm sorry, I don't.
The Fourth Circuit had a case in which there was a final order. Came to the Fourth Circuit then, and then the Fourth Circuit remanded in the way that you're asking us to do?
Well, the Fourth Circuit did not conclude that 46-110 gave it jurisdiction. And so neither the Fourth Circuit didn't reach that conclusion, and the district court also didn't reach that conclusion. So that's one example. The Ninth Circuit in Jonas Fikre v. FBI, they also parsed through the application of 46-110 and concluded they made a distinction. Are you challenging the redress procedures, or are you challenging the initial placement? And Jonas Fikre v. FBI made a distinction between the two and said that the case before it was a challenge not to the TSA particulars, but to the underlying placement. The Fourth Circuit, Your Honor, in that Saad Long case, they remanded with instructions to investigate the whether the complaint in the first instance regarded the TSA administrator's decision. But in that case, the Fourth Circuit was very clear that the broad scope of the claims had nothing to do with the TSA administrator's decision. And so that's an example, Your Honor, of the court understanding that there are some TSA administrator issues mixed in and allowing the district court to parse through them. That's not the approach, Your Honor, that the district court took in this case. The district court said instead that everything is too close to the no-fly list, and because of that, all of it is precluded by 46-110. That just proves too much, Your Honor. It's the no-fly list has nothing to do with what CBP does with Saad bin Khalid's watch list status at the border. It has nothing to do with what USCIS does with Saad bin Khalid's watch list status in processing his wife's immigration papers. It will have nothing to do when the Department of State considers his passport or his children's passport in the future. That has nothing to do with the TSA administrator at all, either before or after. And with that, Your Honor, if there's no further questions, I'll save the balance of my time.
All right. Mr. Wald. What's your understanding of the Long decision from the Fourth Circuit?
The Long decision, like the Ficker decision in the Ninth Circuit, dealt with a unique circumstance where the plaintiff was removed from the no-fly list, and therefore there would be no conflict between a simultaneous adjudication by the district court of watch list or initial no-fly list status and the TSA's final order. So it's completely distinguishable, and I believe the district court addressed that circumstance in its opinion. So the essence of what the district court was saying here is that if it were to review the watch list decision, and let me just step back and explain the relationship between the two. A person cannot be on the no-fly list without first meeting the lesser standard for being on the watch list. And then they must meet a higher standard on top of that to be on the no-fly list. As a consequence of that relationship, you cannot remove a person from the watch list without also removing them from the no-fly list. And the district court reasoned, therefore, any relief that I might give you would necessarily affect the DC circuits or whatever court of appeals was handling the case, would necessarily affect their jurisdiction over that TSA final order that is exclusive in that court.
That's just a strange, effect, yes, but aren't there all kinds of situations in which proceeding in another court or another forum would affect a case pending elsewhere? And we don't see that as like a jurisdictional conflict so much as just the interplay of different legal determinations. Like if I were, saying I was excluded from some program for medical doctors. And in a separate proceeding in another forum, my medical license were removed, and that would moot my case that I was unlawfully excluded from some opportunity for medical doctor, but it wouldn't interfere with the jurisdiction of the court that was deciding my challenge to my exclusion.
Right.
It just changes the underlying facts. And that it seems like that happens all the time. And why is this not just the relationship between a district court challenge to placement on the watch list and a challenge to an order, a TSA administrator order in the Court of Appeals? Why is that not a similar relationship?
Well, I think because I don't know what all the nuances of the situation you described, because I'm not familiar with the medical licenses regime. But I would imagine that a decision in one doesn't have any necessary consequences for another. But you are correct that
If I'm not a doctor, then I'm not eligible for the doctor position exclusion from which I was challenging in the case that is, here, like the 46-110.
Right, but it might also be that there is not necessarily an exclusive jurisdiction regime for hearing one claim versus another. But there are instances where, in fact, courts do decline to entertain claims because of this particular conflict. And these are useful for analogy. Heck versus Humphreys is one that comes to mind, which is if your 1983 challenge for malicious prosecution is necessarily going to affect the validity of the underlying conviction.
Well, but that's a substantive requirement. It's not about one court's jurisdiction running into the other. It's that
Right. And you're
undoing something. But that doesn't seem like that.
Well, it is by analogy, and other analogies are like Younger abstention, where there'd be a state court proceeding, and there it's more of an act of equitable discretion than of jurisdiction. But sometimes these things come up in jurisdictional ways, like in track, where if somebody tries to go to district court in the face of an exclusive jurisdiction regime and claim, well, we're not really in the exclusive jurisdiction of the Court of Appeals because we don't actually have that final order. We've stopped and we've gone at an earlier stage. The courts say, by implication, your claim belongs in the Court of Appeals, because otherwise it would affect the exclusive jurisdiction of that court to order the kinds of relief that Congress has channeled to that court and not to the district court.
But our jurisdiction was exclusive in track over something that we had jurisdiction over, whereas you're saying the Court of Appeals jurisdiction is exclusive of something over which we don't have.
Well, it depends on which claim we're talking about. I think it's
the watch list claim.
Okay, I was talking about the claim for initial placement on the no-fly list, which is sort of one of the claims that the other side brought up. And that falls in the heart of track, which is if you start down the road of agency proceedings that are going to culminate in an order that this court has exclusive jurisdiction over, and you stop in the middle and then try to go to district court, that falls in the heart of track, which is even though you don't have the final agency order yet, you would at the end of the process, and you can't stop in the middle and go to district court. Now, when it comes to the watch list.
If we have lower court cases or agency decisions that could undercut our jurisdiction, then sometimes can't we just issue stays to protect future jurisdiction?
I think you could, but sometimes it depends on whether or not that you view the problem as a statutory jurisdiction problem or as an Article 3 problem. Because if it's an Article 3 problem, I don't think you would stay. You would just say once there's no jurisdiction, you're done. And what my reading of what the district court did here is it said, to the extent that you're purporting to challenge TSC's initial no-fly list decision, that is essentially like a track type decision where you really need to bring that in the Court of Appeals. But with respect to the watch list decision, that is a redressability problem because there's no relief the court can grant that wouldn't effectively undermine this court's potential jurisdiction.
When you say the court, you're talking about the district.
The district, exactly. And one of the problems that it pointed to was the potential for conflicts of judgment. And although it didn't say this explicitly, it's important to realize that although here we're talking about the district court here in DC and the DC circuit, because of different venue rules that apply for a district court case under 1331 versus the venue rules that apply for a TSA order under 46-110, you could potentially have a case in California District Court on the watch list and in DC on the TSA final order. And then you never even have any way of reconciling them because they're not even in the same jurisdiction.
I guess I'm still not entirely understanding why, if I were erroneously on the terror watch list and it was affecting my ability to fly, if I never chose to use the administrative process, you don't dispute that I could bring a district court case to both. I think you concede that in your brief.
I think you might avoid some of the threshold jurisdictional problems, but you would run in headlong into terrible problems on the merits. Because if you're bringing a due process claim that says, I don't get notice and an opportunity to respond, and the easy answer is, but there's a redress process available to get that, and you didn't avail yourself of it, you're just going to fail on the merits. So maybe you avoid these problems, but you just raise other ones. You're out of the frying pan with the fryer.
Your position is that the redress process in a suit against the TSA, a plaintiff can get redress for a baseless, erroneous placement initially on the watch list and on the no-fly list.
I'm sorry, can you repeat that?
On the watch list and the no-fly list through a challenge, 46-110, channel to Court of Appeals, can challenge both of those things before us.
I think so.
Inextricably intertwined.
Yeah, I think there's sort of, I think you're essentially asking me, what is the plaintiff supposed to do in this situation if they want to challenge both simultaneously? And we think that the answer is, if you, in the unusual circumstances of this case, where you are on both lists currently and you want to challenge them both simultaneously, that the TSA final order, I think, as the first case, definitely belongs here. And in that posture, all the other challenges are inextricably intertwined and could be brought in this court under 46-110. The other thing that you could do, if you wanted to, is just challenge the no-fly list order, TSA final order in this court. And if you prevailed, then you could bring your other claim in district court if that's how you wanted to proceed. But
You do it the other way around. You want to bring a
no, I don't think
claim to the watch list
yeah, I don't think that you,
only.
yeah.
You can't do that
I don't
in district court and say there's no due process.
I mean, if
with
you're-
respect to my placement on the watch list.
Well, at that point, the only way you know you're on the watch list and get notice is if you go through
that's
the
lucky
redress
for you,
process.
but if I did know, if I intuited,
Yeah,
my name is Ted Kennedy, and I know there's an IRA person whose name is Ted Kennedy, and I want to challenge that. So I'm just going to take a chance and
Yeah.
say, I believe I'm on this list. I'm going to sue. You don't dispute that you could go into district court on that?
I wouldn't say that, Your Honor, but I think it's first of all, it's a different case than what we have now. And I don't necessarily think in this case, you need to map out all the different permutations
Every
and how you would
hypothetical
do
is a
it.
different case. I'm trying to understand the basis.
No,
of the
I understand.
position.
I think that part of it would be a question. I think the most relevant way to think about it is, would this fall under the artful pleading rule? Are they really trying to get at the no-fly list decision by attacking the watch list? Is that really the heart of the case? And here, I think it is this is what it started as a no-fly list. It started with him in another country, unable to fly back. And he went through the whole redress process. The complaint is up and down about the no-fly list, and that's really what this is about. In your hypothetical, I think you'd have a question of, is that really what that kind of case is about or not? And so it would depend on the facts and the circumstances, and I'm hesitant to give a one-size-fits-all answer for that. But one thing that I do want to point out is everything that we focused on in our brief and so far today has sort of focused on the question of, was the district court correct to deal with it in the jurisdictional way that it did? But another way to look at this is sort of, now this case is before this court, and we just had this other case, and you're going to go to conference after this and you're going to decide that case. And in this, if you were to agree with the government and affirm the TSA's final order and maintain him on the no-fly list, I think at that point, whatever the district court did, it follows from that there's no relief that they could be granted on the other claims that wouldn't necessarily undermine the judgment that you had just rendered, keeping him on the no-fly list.
But you
I
also
see.
indicated that we could look at the entire record, the antecedent,
Yes,
legal determinations.
Yes.
And to do that.
yes,
And you also indicated earlier that in doing so, if there was something that we found problematic, even though TSC is not at the table, whatever order we issued that affects TSC's action, it still is against TSA, but in effect, deals with TSC.
yes, because any order, anything that the TSA does, if it on its own, if it had removed the person from the no-fly list during the redress process, that would be carried over to TSC. It
And
would
you don't consider TSC not having due process to be at the table for this to be sufficient? I'm just thinking about the EGE, I think, case.
Yeah, so yes, that was a case that existed before the current procedures.
Okay.
Where TSA was not issuing the final order. Now, after 2015, TSA issues the final order. And in fact, Busick deals with this situation and says EG is no longer operative in this context once TSA is issuing the final order. And so what I'm saying is here, if you were to affirm TSA's final order and he's going to remain on the no-fly list at the end of case number 1 here, at that point, all the harms that he alleges at the border, unable to fly, all of those things that he says are going to come just as much from his status on the no-fly list, which you would have just affirmed, as it does from the watch list or the TSC initial decision.
Why? The no-fly list doesn't deal with land borders. It doesn't deal with visa claims.
Well, what his complaint says, my visa is being delayed because I'm on both of these watch lists, and he would remain on the no-fly list. And number 2, at the border, the policy about searching the cell phone searches that he's referring to says if you're on a watch list, which no-fly list is a watch list. And I don't think anyone is disputing that if you remained on that, you would be subject to the cell phone policy the same as if you were on just the other watch list.
I'm having trouble following, and you've said this, I think, a few times and just quite clearly in response to Judge Child's question. How can we review the challenge to the process by which the plaintiff got on the terror watch list when our special statutory jurisdiction under 46-110 extends only to the TSA administrator?
Well, the district court addressed this question, Your Honor, and I think the answer is you couldn't because there's no standing, which is to say there's one process if you're a citizen who's on the no-fly list. If you're not on the no-fly list and you're only on the watch list, you get a different procedures. And what the district court said is, but you didn't get those other procedures because you are on the watch list. So you got a different set of standards. So any challenge to the procedures you would get if you were exclusively on the watch list and not on the no-fly list is an academic question because that's not the procedure you got.
Challenge the procedure. You can't challenge before us the procedure by which you were originally put on the underlying terror watch list in a suit, in a challenge to a TSA order.
I would put it this way. In a situation where you did not get that type of procedure, you cannot challenge the adequacy of a procedure that wasn't applicable to you. That's what we're saying. And so that is, if you want to just challenge the procedures you would get if for someone who is solely on the watch list and not on the no-fly list, you could do it if you challenge your no-fly list status, get removed from that, and then say, I'm still on the watch list and I want to challenge that. You could, in theory, do that. I mean, part of the problem here is that he's trying to challenge sort of everything at once when they're all intertwined. This has really never happened in a watch list case, as far as I'm aware, and I've been litigating this for 20 years. So it's a little bit sort of unusual for the posture, but the fact of the matter is, if you are only on the watch list and not on the no-fly list, you're not going to get notice of your status. You're not going to get an unclassified summary. And if he wants a challenge, is that procedure adequate? I think the district court's answer is you can't do that because that's not the procedure that was applied to you. If that procedure is ever applied to you, you can then challenge it. But that's not what happened here. It's sort of an academic question. And it's one that, by the way, no court has addressed it as a due process matter because 5 circuits have held when you're only on the terrorist watch list and not on the no-fly list, you don't have a due process liberty interest at that stage. So no court has ever reached that question. And so I think you'd have some merits problems as well, aside from the jurisdictional ones that you encounter in this particular posture.
Right?
Okay, thank you, Your Honor.
All right. Is there any time of- Okay.
Your Honor, I'd just like to begin with a bit of a hypothetical. Let's say, for example, the inclusion standard for the no-fly list was whether or not you had red socks. The risk of erroneous deprivation in applying that standard would be very low. It's easy to tell if somebody has red socks or not red socks. And if you got to DHS TRIP, the standard that DHS TRIP would have would be, that they would be applying would be whether the person has or does not have red socks. What we're challenging is not how TSA administered the standard that it inherited. We're challenging the actual inclusion standard, the one that the FBI, the Terrorism Screening Center, initially used against Saad bin Khalid to put him on the no-fly list and to put him on the watch list. And that's why you can locate the challenge itself, the target of the challenge, where we're aiming it at something that the Terrorism Screening Center has and does and applies, and not something that the TSA administrator does itself. But when you get to the merits, you can see that the interaction between some of these claims in 46110 is yet another reason to send the case back. For example, the substantive due process claim. For the substantive due process, those rights, they can only be violated via the least restrictive means, no matter the process. The substantive due process is actually opposed to the process itself. And so, but 46110 says that if there's substantial evidence of a fact, it's conclusive. This court is to treat it as conclusive. That's the exact opposite of what you're supposed to do for a substantive due process right. So, for example, in this case, the allegations of the complaint are that the no-fly list is useless, that it does not enhance aviation security, and that it's if anything, it's certainly to get in all these cases. It's even the Northern District of California did a trial. They did a trial and they found out the reason why the person was placed on the no-fly list. It was because the FBI agent accidentally checked the wrong box. And so it is absolutely possible in the district court to get the underlying reasons, to get summaries of the underlying reasons, stipulations. We've gotten stipulations in the District of Maryland that help us work through these kinds of searching of electronic device claims. And so, Your Honor, this case does belong in district court. It's fact intensive, and if there are no further questions, I'll stop. Thank you.
This honorable